building democracy. That's what the real focus of our campaign is.
And the Wolf campaign, challenging corporate power, asserting the people's rights, and especially on this campaign to abolish corporate personhood, we decided to take our inspiration from the abolitionists. They had a big battle to fight. And they looked at what they had to do, and they said, this is so wrong that the whole thing must be abolished. No tinkering. They didn't say, gee, can we start a slave regulatory agency, maybe, and or voluntary codes of conduct for the slave owners, or maybe we could get all the abolitionists together and agree not to buy slaves. They just went, it's not going to do it. We got to get rid of the whole thing. We've got to abolish it. And since it is just a fiction, legal fiction, it can be done. It's not a law of gravity. It can be changed within our laws. And that's why we have these T-shirts. That slavery is the legal fiction, that a person is property. Corporate personhood is the legal fiction, that property is a person. The way we're defining corporate personhood for this campaign is when corporations have rights in the Constitution that were expressly, intended for human people, like the Bill of Rights, the 14th Amendment, and civil rights legislation. So that's what we're talking about when we say corporate personhood. If we want to know how to end corporate personhood, the corporate lawyers have already made us a roadmap. All we have to do is undo it. But basically, they told us what they were doing. We just have to undo it. And that gave me sort of the idea to make a timeline, to make the roadmap, to put it out so that we could see what it was that was done, so that we could understand what to undo. In our town, we didn't have the timeline at that time. In fact, we had nothing. We just had a good idea that we wanted to abolish corporate personhood in the town of Point Arena. So our idea was to put it on a ballot initiative and let the people vote on who is a person. But we found that we could not put ending corporate personhood on the ballot because you're not allowed to vote to take away the rights of a person. So we thought, well, gee, what can we do? And we finally ended up with that we could pass a resolution through the city council, and they could say the corporations were not people. And that is what we ended up doing after much education and difficulties. They did sign 2 years ago in a resolution that says, basically, they were agreeing with Supreme Court Justice Black, saying that corporations were not persons to be included under the 14th Amendment. But it was the first time that an elected body anywhere had said anything on the subject. Sitting president at the time was Thomas Jefferson. Now, when the Supreme Court declared itself to be supreme, Jefferson wrote this opinion. If this opinion be sound, then indeed is our Constitution a complete felo de se, legally a suicide. For intending to establish 3 departments, coordinate and independent, that they might check and balance one another, it is given, according to this opinion, to one of them alone the right to prescribe rules for the government of the others, and to that one too, which is unelected by and independent of the nation. The Constitution, on this hypothesis, is a mere thing of wax in the hands of the judiciary, which they may twist and shape into any form they please. Well, he was right. He was really right. It became a ball of wax. And in many other areas, not just corporate personhood, this ball of wax has been molded and shaped. It's like from then on, the judiciary could decide what they wanted the outcome to be and make it happen. Where the heck was Congress? When people get rights, they get them through amendment. It's hard, it's long, but that's how we do it. We get amendments. People's rights come through amendments. Corporate rights come through the Supreme Court giving it to them. Okay, corporations are not in the Constitution. It's the only thing that's important is stockholder profits. So now the corporations are going for the push on the First Amendment. Buckley versus Vallejo is the money equals speech. You've probably heard about that when they decided that money equals speech for political purposes. And since a corporation can't speak with its mouth, it can speak with its money. Commercial speech is protected. Advertising now becomes free speech. This case, Boston versus Bellotti, says unlimited money can be spent to overturn referenda. So with the combination of Bellotti and Buckley versus Vallejo, this is why we can't do campaign finance reform. And they are First Amendment rights that go back to personhood. This is the 14th Amendment that we've been talking so much about. It reads, "Nor shall any state deprive any person of life, liberty, or property without the due process of law, nor deny to any person within its jurisdiction the equal protection of the laws." And then the 15th Amendment gave voting rights to black males. This word person became very contested. What could it possibly mean? Well, in an attempt to clarify things, Susan B. Anthony went to her local polling station and cast a vote on November 1st, 1872, justifying her vote on the grounds of the 14th Amendment. On November 12th, Anthony wrote, "All persons are citizens, and no state shall deny or abridge the citizens' rights." 6 days later, she was arrested for illegally voting. The judge, noting that she was female, refused to allow her to testify, dismissed the jury, and found her guilty. Lacking the resources available to huge corporations, she was unable to repeatedly carry her cause to the Supreme Court as the railroads customarily did, and that judgment stood. At the same time, and just the day after, actually, Minor v. Happersett was decided the day after the slaughterhouse cases, where corporations went to court and asked, could they be considered persons under the 14th Amendment? And the judges said no, and they specifically said no, and they said the 13th, 14th, and 15th were just for black men. So they had actually made a judgment that it was not for corporations, not for women, yes, for black males. But the railroad corporations really, really, really wanted personhood. And maybe other corporations too, but the railroad cases were the ones that really pushed it. In the railroad cases, Senator Conklin, who was the last surviving member of the committee that wrote the 14th Amendment, he gets up in court and he's waving these papers, and he just had a fistful of papers. He said, "These are my notes that I took during the meetings." And I took notes saying that we had always intended corporations to be included in the 14th Amendment. But no one's ever seen those papers. They've disappeared. And the railroad cases were decided on other grounds. They did not deal with personhood. Corporations became people in this decision under the law. Persons with the rights of the 14th Amendment at this point. Only the last part, the equal protection part. But they just inched up after that. Of the 14th Amendment cases brought before the Supreme Court between 1890 and 1910, 19 dealt with African Americans and 288 dealt with corporations. When these cases come into court, these 288, what they're doing is they're challenging state law that was put in by elected representatives. They're challenging state law. And in 200 cases, they overturned it. So that's primarily what this 14th Amendment allows them to do. It allows them to go into court on almost any pretense because they have the right to go into court and challenge state law. State law, because it says state in the 14th Amendment. Judge-made law is not democracy. And that's kind of our point. We didn't vote for any of this stuff. We didn't vote for the judges. And these decisions, this decision, real important decision, about money and politics, was 4-5, 5-4, or whatever. It was by one man, really, that did this. The corporate theory from the beginning all the way through here it's called the artificial entity corporate theory. The corporations are artificial entities under the law. They are not people. They do not have the rights of people. That's up to here. Then the theory changes. Now they're people, and they have the rights of people, all the way till the 60s, when they suddenly switched again. And they're saying it doesn't matter whether a corporation is a person or not a person. What matters is, what is the First Amendment, or what is the Fourth Amendment? So you're supposed to look at the First Amendment and say, is it better served by corporations having this right or not? That's how they're writing their opinions now. They're not saying corporations are people. They don't want to get into that argument. What they're saying is, it's better for the First Amendment if corporations can have this speech. And so if we were to fight it at the Supreme Court level, that would be the argument we would probably be having to use, is it's not better for the First Amendment because corporate speech is too loud for our voices to be heard.